As a public defender, Judge Karen fought for her clients' rights. She was elected to the bench because she believes in doing the right thing.
I'm very passionate about helping people, period. Y'all two grown people need to get your own house.
Right.
You had 7 years to have told him that. When we fight, who's gonna win?
You are.
I don't answer questions, I ask them.
Yes, ma'am.
Raise your right hand.
Objective, independent justice.
I'm ready to rule. If you keep walking, you can overcome whatever circumstances you're facing.
This is Supreme Justice with Judge Karen. Chad Tillman is suing boxing trainer Cedric Young in the amount of $625. Mr. Tillman claims he hit the mat hard and was injured while sparring, and says Mr. Young knew he was a novice and didn't provide a safe training environment.
So, Mr. Tillman, you are suing Mr. Young for $625 representing medical bills.
Yes, and also unused training
and
fees.
unused training courses that he offered. Is that correct?
Yes, ma'am.
And you
Yes,
suffered some injuries.
Yes.
All right. So, how do you know Mr. Young?
Mutually, he went to school with my brother, my older brother.
Okay. So you grew up around him?
Well, he used to box professionally, and I got word around the neighborhood that he has a training.
Oh, okay.
Situation
You were a
at his
professional
house.
boxer?
Yes, ma'am.
What weight category?
Middleweight.
Middleweight. Okay. Okay. So you contacted him because you heard that he now has what? Would you have a training camp or something?
A training gym. Yes, ma'am.
You have a training gym.
I do.
So when he hit you up, did you tell him, okay, I'll take you?
He had to remind me who he was, but once he reminded me who his brother was, then I was like, all right, come on.
Oh. So you wouldn't have taken him otherwise?
No, ma'am.
Why wouldn't you have taken him?
Give me a raw expression, but
I never did nothing to him. I don't know.
But you didn't think
He
he
don't
could
look-
fit?
he
It's
don't
just
look-
a boxing training,
I
though,
know,
isn't
but
it?
he don't look like he can scrap for real. He don't look like he got the dog in
I'm
him.
nice.
So I was like,
I'm
like,
nice, Sean. I don't know what he's talking about.
He
I'm
say
nice.
he's nice, but
You're not training people to become boxers.
I am.
Oh, you're training them to become boxers.
Yes.
Did you understand that that's what he was training?
I didn't want to go in to be a boxer.
Right.
You know what I mean? I just
But
want to
what
get some
did you
training and stay
think
active.
he was training people to do?
Yeah, I just want to learn how to box. I didn't want to,
Well, and how old are you?
I'm 34, man.
Okay. You weren't under any false impressions that you were going to become some great boxer.
No.
You just thought you were going to be getting some training.
Yeah, I just want to stay active.
And you said you would not have taken him.
This exchange clears up something crucial. Chad never claimed he wanted to be a professional boxer. He wanted fitness, skills, activity, not competition. That distinction matters legally. When someone enters a dangerous environment without professional ambition, the standard of care shifts. Judge Karen is making sure expectations were aligned. Because if a trainer knows a client is casual, inexperienced, and just trying to stay active, pushing them anywhere near sparring becomes a serious liability question. Ask yourself, if you sign up for boxing training, do you automatically consent to getting hit? Or does consent depend on experience, instruction, and supervision? This isn't about toughness. It's about informed participation.
Except for your relationship
brother.
you had with the brother. So you knew that he wasn't of the ilk that you
Exactly.
expect, because you're looking for people that really want to go professionally with this?
Not always professionally, but if they come to me and they're eager, I'll give it to him. He's eager. He's very eager.
Okay.
But I did not tell him, we'll get to that, but I did not tell him to get in the ring yet.
How much does it cost?
It costs $75 a month for 6 months.
And how often does he come in?
He comes once a month.
Oh, one time a month.
Every third Thursday.
How long is the session?
About an hour to hour and a half.
About an hour and a half. So what happens the first session?
Boxing techniques. He would show me boxing techniques.
Running on the
We
treadmill.
would jog and run a lot.
What were you training?
Running on the treadmill,
Right.
jump rope, hit the speed bag.
Right, you were doing
Yeah.
that jumping rope?
Yeah,
You
stuff
done
like
this
that.
before?
I have done that.
Oh, have?
Yes.
Okay. You two train as a boxer?
I did not train as a boxer.
Oh, okay.
Come train with me. Come train with me.
Just,
I got
would you take him?
Hey, I'll take you. Come
Hey,
on.
there you
Come
go.
on, I got you. I got you.
$75.
$75
You
a
can
month.
afford that.
Come on.
Hey,
Did I-
It's once a month?
once a month.
It's just it's wild that it's just once a month. So then what happened? First month was good.
Yeah.
Second month?
Same things. pretty
Good,
much.
great.
Yeah.
He's getting better?
A little bit.
He was getting
I
better?
give it to him. He was getting better. He's very eager.
Okay,
Very eager. So
wanted
he
to
wants to go
learn.
learn, but he's all over the place.
What you mean he's all over the place?
So I'll tell him to go run. He'll go run a little bit and then try to go hit the bag. I'll tell him go hit the bag. He'll stop. He'll go get some water. He'll go talk on the phone. So he's like, he's
But that
there,
don't
but he's
sound
not
too
there.
eager.
No,
Were you
he's
using the
exaggerating.
phone during your session?
No, he's
It's
exaggerating.
1 hour every 30 days.
Couldn't give
I
him
would
30
think that
minutes.
you could concentrate on that 1 hour of time.
Well, of course, Your Honor, but he's exaggerating. I
You never
wasn't
used
on
the
my
phone.
phone. No,
never used the phone.
Never used
no,
your phone.
No.
Okay.
No.
Here's where credibility starts cracking. Cedric paints Chad as unfocused, distracted, and unserious. Chad denies it completely. In court, this becomes a credibility battle. Not about boxing, but about truth. Judge Karen doesn't let exaggeration slide. 1 hour a month means distractions matter more, not less. If someone's distracted, whose job is it to stop the session? The trainees or the trainers? This moment isn't about phones. It's about supervision.
He's exaggerating.
Okay, what else did you say? Well, he could go off and get some water,
I
though.
think he hit his head on the
human.
way down.
He hit his head on the way where?
On the way down, and I don't know.
What you mean hit his head on the way down?
Because he got hurt pretty bad, and he fell pretty hard. I thought it was my daughter screaming. So
Oh, please.
I was like,
Was this
hey.
the third session?
This was the third session.
Okay, what happened on
This is
Thursday?
supposed to be the sparring session. That day, it was told to me at the beginning of the training process.
Right.
The third session.
Right.
We were supposed to be
We're
sparring.
gonna start sparring.
Yeah. No, it was 8 of us in the session.
Oh, it's not
if I'm
just
mistaken.
you.
No. It's more, and we partnered up.
Okay, so is everybody all dressed for sparring?
Yeah. Yep.
No. So he's telling partial the truth. When they first started, I said, hey, everybody should be good enough to be able to spar around the 3rd month.
You should be.
You should be. But you have to come to me to be free to spar, and I had to pick who you spar. He shouldn't have even been in the sparring ring. I told him to go run. There's a
Right.
bottom half and there's a top half.
Right.
So he's a part of the bottom half.
What's the bottoms do?
The bottoms do the endurance, the regular stuff.
Right.
They don't
They're
really
not.
do
The top 4 are the only ones
the
that were
top
supposed
4
to
should
spar.
have been the only ones that are spar. And
So
because
how
the
does
trainees,
he end up sparring?
Because the trainees asked him to go spar, not me. No
Okay,
man.
what happened?
Well, he's correct about one of the other participants asking me to box with him, to spar with him.
Right.
But this was after 2 sparring sessions already occurred.
Don't you have to get in the ring to spar?
Exactly.
Okay, didn't you see him get in the ring?
No, ma'am.
Where were you?
I was with the bottom 4 when I told him to go and run.
Oh, I see. The top
the
4
treadmills.
were done.
Yes.
You go now deal with the bottom 4, but
Yep.
then you notice it was only the bottom 3?
I told the bottom 4 to go and get ready to spar.
Right, that-
And then I went to the treadmill.
But he is the bottom 4.
No, I
I wasn't
told
told
the
about no bottom 4. About
Okay,
anything
wait. No,
Sorry, Your Honor.
no in your head now. He is the bottom 4.
Yes.
Coming up on Supreme Justice.
What happened when you started the sparring?
Well, we was going for about a minute, and then I got hit. You know what I mean? Everybody gets lucky. I got hit on
Right.
the side.
Right.
I
But
hit
you
the
know, did you
canvas.
pick and roll and everything?
And later,
At the end of business day, I had to get his car towed.
Why would you put him in that situation?
Ma'am, this is not the first time that he's been late on a pickup of his vehicle. I've serviced his vehicle many, many times.
Like how many times has he been late?
2 other times.
if you'll be in the Los Angeles area and want to bring your case to court, call 1-888-552-6878. You're watching Supreme Justice with Judge Karen. Supreme Justice is back with the case of Chad Tillman, who is suing Cedric Young for medical expenses and training fees.
Bottom 4.
Bottom 4.
We're
come
going
on,
down
do
here.
endurance, jump rope, everything like
That's
that.
right. Come bring your ropes. We're going to jump.
Yes.
He is not down there because
I told him, he was down there with us,
Okay.
and I told him, go and run. He's
Did
not
he
running.
tell you to go run?
No.
What did he tell you?
I didn't tell you go
This
run.
was we supposed to be sparring this day.
Oh, man.
He said that we was sparring.
What happened when you started the sparring?
Well, we was going for about a minute, and then I got hit. You know what I mean? Everybody gets lucky. I got hit on
Right.
the side.
Right.
You know, and I
But
hit
you
the
know,
canvas.
did you pick and roll and everything? And
No, I
you're
got
supposed
mine
to
in.
always.
Oh, no, I got mine in, Your Honor.
Yeah, but you're
I did
supposed
my
to
thing.
always protect your middle. I remember that from boxing. Is that your arm never? Am I right? Tell me.
Middle on your
There you
face.
go.
There you go, and your face.
Middle on your face.
Look at him.
You're not wrong. You're not wrong, Your Honor.
Okay, middle and the middle and your face.
You're not wrong, Your Honor. But like I said,
Right.
he got lucky.
So then what happened?
I hit the canvas.
Right.
A couple of other participants helped me get up off the canvas.
Right. What, did you see him when he hit the canvas?
This is where emotion meets evidence. Chad hits the canvas. People help him up. Cedric hears it, turns around, and is surprised Chad was even in the ring. That surprise says everything. In law, surprise often equals lack of control, and lack of control in a high-risk activity can equal negligence, depending on the circumstances. Judge Karen isn't moved by toughness talk. She's listening for responsibility.
I heard him.
Oh, you heard him.
I heard him.
And what happened?
So when I heard him, he was screaming, and I turned around, and I was confused on why he was inside the ring. So I jogged over.
All right.
I said, "What happened?" And Chatty over here was all trying to be tough guy, like, "Oh, I'm good, coach. I'm good, coach." I thought he was good. I let him get up like a man.
Right.
So
I thought he said some people had to help him up.
yeah, so they did. They
Okay,
did.
but so he didn't get up like a man.
Didn't get
He
up.
got a man
I
with
wasn't gonna
help.
say it. I wasn't gonna say it. I was like,
so,
I'm
but
trying
he had to have help getting up.
He did.
And so now you're suing for what? The injury?
Yeah, absolutely. Well, I'm suing for medical costs and
Right.
the unused training fees.
Right.
So there's still
So-
3 months left.
Okay, well, he can't use the 2 months. You can't use the 2 months?
I don't want to
Because what?
because I don't trust. I don't want to go back and train with him. I feel like he
He
was
never told you to
unprofessional.
go into that ring. It looks like there was 4 people that used to do this and 4 people who are better than that, and they did other things, and you weren't in that group, and he was away from you with that group of bottoms, and you were up there tussling with somebody that was better prepared than you. You made that decision. So you're not getting that back. And what about these 2 unused courses? What's that?
I tell every-
$75? What's that times 2?
150.
I
You're
freeze
getting
this.
better.
Oh,
Hey,
$150. You really? So it's $150 left.
Well, actually 3 months. So 150 plus it's 225.
$225.
Yeah, so 400 altogether.
Oh, okay. So you don't want to go back,
No.
but you're the one breaching the contract here, not him.
How
You're
is
the
that?
one, because you're the one saying you're not going to go back.
Well, I felt like he's unprofessional by the way he handled it.
Well, I'm prepared to rule in his favor on the medicals because I believe you were negligent there, not him.
This is the legal heart of the ruling. Judge Karen finds Chad negligent, not Cedric. Why? Because Chad entered the ring without clearance, without instruction, and without supervision. This ruling reinforces a harsh truth. Choosing to engage in a risky activity carries personal responsibility, even if the environment is imperfect.
He has not breached the contract. Is he free to come back to you for
yes, he
lessons?
is. Yes, he is.
Could he sell those lessons to somebody else?
No, I actually freeze them. So I tell everybody before they sign up,
Right.
if you need family time or
Right.
if you get injured, need some
Right.
time before you come back, I can freeze your membership. Just
Right.
come back whenever you're ready.
Right.
If I start giving them money now, everybody's gonna want a free handout. Everybody's gonna want some special treatment.
Right.
I told them I don't run like that.
Right. You don't run like that. And so what are you going to do about your future, this whole physicality thing that you were trying to get better
I really
at?
was just trying to stay active, trying to stay
Right.
in shape. I wasn't trying to become a professional, but
Right.
I don't
But
think.
you know, there are other things that you could do. I mean, boxing. I mean, at your age, do you want somebody to hit you in your face, or somebody to hit you in your stomach? I mean, isn't there stuff he could do? Isn't there golf? Isn't there
basketball.
tennis? Isn't there pickleball? Name some sports that he could do.
He could swim.
Jog.
Yeah, swim,
Yeah.
Go swim.
jog.
Yep.
What else?
Ballerina.
I ain't stop with it.
Ballet.
That was a joke.
You could go. You could go walking. You could do what? Weight training.
Weight training.
Don't you do weight
Yeah,
training?
weight training.
Weight
Yep.
training. I mean, boxing just would have been at the bottom of my list if I just was trying to get active.
Well, I like contact sport. I mean, I wanted to try it out. I never did
Right.
before.
Well,
I
now
figured.
what you think? What's your thoughts?
I don't know what I think now, but
Okay.
I know I don't want to go back to train with him.
Okay,
if
well,
I do
you make
decide to
enough
go
money.
fight.
You're not going to miss this little bit of money. I can't believe that you took all the time out of your money-making day to bring a lawsuit for $600, really, quite frankly. Anyway, judgment for the defendant. Good luck to you both.
All rise.
Judge Karen has ruled in favor of the defendant. The plaintiff's claim is denied.
If he ever come back, I'll still be willing to teach him, but I already knew what was going to go down.
I didn't think I gave a fair chance and wasn't aired out. So, but no hard feelings. I just move on. I go train with somebody else.
Coming up,
I repeatedly told him that he must be back on Friday to pick up his vehicle. I made that very apparent.
Really? He said he repeatedly told you got to come pick up this car on Friday.
I did try to get some friends to pick it up because I wasn't going to even be there.
New case, same theme, responsibility. This time it's a car, not a body. And again, assumptions cause conflict.
you're watching Supreme Justice with Judge Karen. Denver Sealess is suing Mark Canty in the amount of $568.88. Mr. Sealess claims he left his vehicle at his mechanic's for repair and says Mr. Canty had it towed before he could pick it up and owes for the towing fees.
All right, Mr. Silas, you're suing Mr. Canty for $568.88, and this has to do with a towing charge. Is that right?
That's correct, Your Honor.
Okay, and what's your relationship to the defendant?
Well, besides being a close family friend, he was my mechanic, and I had my car under his care.
Okay. How long have you known him?
Since I was about 16.
16 years old. He was a friend of the family. So he's been around you, Thanksgiving dinners, Christmas, that kind of thing? That close a friend?
He even dated my aunt.
Oh, he dated your aunt?
Yeah.
All right, so how do we end up here?
Well, Your Honor, I came to him because I had some issues with my car.
Okay. And you're a mechanic?
Yes, sir.
Okay, and what do you do?
I'm an actor.
You're an actor, okay. And where do you act?
Well, it's actually kind of the cause of the problem, Your Honor.
What is that?
I went to New York to get an interview, audition with some of the troupe members.
Okay, so what did it have to do with the defendant?
I left my car in his care, and he apparently did not have enough room.
So what do you mean? What was the understanding, Mr. Canty? He's going to go to New York now, and he wants you to take care of the car.
I took in his car on Tuesday
Right.
and diagnosed it on Wednesday as having a faulty alternator,
Okay.
which I was going to repair and have done to him by Friday.
Okay, but then you were supposed to be back in time to get the car and didn't make it back? Is that what I'm understanding?
I was under the assumption I'd be back on Friday, but
Right.
I also told him I don't know if I was going to be able to pick it up on Friday.
And what did he say?
I repeatedly told him that he must be back on Friday to pick up his vehicle.
Did you fix the alternator?
Yes, ma'am.
Did he pay you for that?
Yes, he did pay me.
Paid
He
you
paid me
that?
for the part. Yes.
Did you think about having a tow company tow your car to your home?
Honestly, Honor, no, I did not.
This is the first time you ever thought about it.
I've never thought of something like that. You're right, Honor.
How old are you?
I'm 26.
Okay, well, that's why you didn't think about it.
Coming up,
At the end of business day, I had to give his car towed.
Why would you put him in that situation?
Ma'am, this is not the first time that he's been late on a pickup of his vehicle.
you're watching Supreme Justice with Judge Karen. Supreme Justice is back with the case of Denver Silas, who is suing Mark Canty for negligence.
So then what happened? What'd you do?
I had his car towed at the end of the business day. I gave him until the end of the business day. That
Right.
was a gesture of friendship, just to give him enough time, but it wasn't enough. So at the end of business day, I had to give his car towed.
Why would you put him in that situation?
Ma'am, this is not the first time that he's been late on a pickup of his vehicle. I've serviced his vehicle many, many times.
Like how many times has he been late?
2 other times, as opposed to this one.
And what happened those other 2 times?
The other 2 times, I let it slide because he's an up-and-coming actor.
So finally he got a big break in New York City, and this is when you decide to put your foot down?
This is the time when I had to put my foot down because I was just tired of the irresponsibility.
But it was not a reasonable thing to do. Let me see these tow bills.
You want-
How much was the tow bill itself?
The tow bill was, the tow bill itself was about $150 and some other fees.
Why are there 2 tow service bills? One is for $190 and one is $125. Why is that?
I really couldn't say, ma'am. I just called the company and I had to take the car away.
So how many times have you done this to people? People who didn't pick up their cars, just call Ironclad Tow Service.
Aside from him, I've only had one other customer that I've had to call a tow service in order to remove their car from my lot.
I don't understand why you have 2 towing fees. Standard tow service is $190 and a flatbed tow service is $125. That doesn't make sense. That should be the other way around.
Judge Karen applies textbook law here. Mitigation of damages. Even if towing was justified, overcharging wasn't. Fairness doesn't mean punishment. It means balance. This ruling shows judicial precision.
Flatbed is always more than standard. How much did Mr. Canty charge you to fix the car?
What was it, about $235?
That sounds about right, Your Honor.
That's a cheap alternator job. What kind of car you have?
I just have an old Honda.
Honda what?
Honda Accord.
A Honda Accord. And a whole new alternator with the installation was only $200 and something dollars?
I cut him a lot of slack,
That
Your
was a
Honor.
lot of slack.
Judge Karen's verdict when Supreme Justice returns. You're watching Supreme Justice with Judge Karen.
I think you had a responsibility to minimize the damages to him. Mr. I used to date his aunt. I've been to Christmas and everything.
I didn't think to, Your Honor.
No, you're not, but you're going to know something better now, aren't you? I'm going to take that $568.88 that he paid, and subtract the $125 for standard towing, that old car, you didn't want to put on a flatbed, spend that money, which leaves a balance of $443.88. So I guess we're not going to be friends anymore after this, huh?
It's going to be hard at Christmas, isn't it?
Yeah. Auntie probably is not going to speak to him either.
I think she was already done with that.
Yeah. I'm ready to rule judgment for the plaintiff in the amount of $443.88. Good luck to you.
All rise.
Judge Karen has ruled in favor of the plaintiff. The defendant is ordered to pay $443.88.
2 cases, 2 lessons, 1 courtroom philosophy. In the boxing case, the court ruled that personal choice carries personal responsibility, especially in high-risk activities. Injury alone does not equal negligence. Contracts matter. Consent matters. Supervision matters. But so do individual decisions. In the towing case, responsibility was shared. While the mechanic had the right to tow, he also had the duty to minimize harm. The court corrected the imbalance, not the relationship. If you found these cases as eye-opening as we did, make sure to hit that like button. Share your thoughts in the comments, and subscribe for more sharp, no-nonsense courtroom breakdowns that separate emotion from the law.